Yes, is it audible now? Sorry for the delay, for the inconvenience caused. I hope the audio is now it's audible. Right, Mir? Okay. Thank you for informing. Some bit of technical glitch. Okay. Yes. So the first question: which among the following is not an ingredient of res judicata? In this, both the suits are between the same parties. B, first suit is tried and finally decided by the court. C, former suit is decided by a court competent to try the subsequent suit. And D, the matter in issue in the previous suit directly and substantial issue in the subsequent suit. So here, what is the correct answer? C. C is the correct answer. Means it necessarily need not be an ingredient, because even if the suit, if the court is of a limited jurisdiction also, still it is a it becomes the res judicata. Second question: which among the following transfers under Transfer of Property Act is an exception to nemo dat quod non habet? A, transfer by co-owner. B, transfer by an ostensible owner. C, transfer for benefit of unborn person, that is under section 13. And D, transfer of property pending suit under section 52. What do you mean by nemo dat quod non habet? No person can pass better title than what he has. No person can pass better title than he has. Right? So, in this question, what would be the correct answer then? It is ostensible owner, B, because this is the doctrine of holding over. We also say in that name, doctrine of holding over. If he is an ostensible owner, then his rights are limited. He cannot pass an absolute title to the other person whom he is transferring. Okay, if the exception wouldn't have been applied. But this one, even though it's made, if the transfer is made by an ostensible owner, due to the exception found here, even the transfer made by the ostensible owner would be a valid one. Next one, third one, a suit for specific performance in relation to purchase of a residential house was filed in 2019 before the Munsif court. Defendant appeared and contended that the suit is liable to be tried by a special court under section 2B of amended Specific Relief Act. Is that contention sustainable? A, yes, since amendment came into force prior to 2019. B, no, since the amendment has no retrospective operation. C, yes, the subject matter in the suit is one covered by section 20B of the Act. And D, no, since subject matter in the suit is not one covered by section 20B of the Act. So, what's the correct answer here? It is D. Okay, since subject matter in the suit is not one covered by the section 20B of the Act, hence that contention is not sustainable. Fourth question: which among the following is true? In a civil proceeding, defendant is entitled to set up inconsistent defences till the end of the trial. B, mutually contradictory defences. C, mutually destructive defences. And D, alternative defences. So, which of the following is true? Defendant, is he entitled to set up inconsistent or mutually contradictory? Yes, Mir. It is, So, defendant can set up alternative and inconsistent pleadings. Pleadings also includes defense, that is why D, alternative defenses, we can consider this. Order 6, order 7 and order 8, order 6 and order 8 particularly here, they are applicable, order 8. Next one, fifth question. Which among the following is true in relation to the term legal representative as defined under Code of Civil Procedure? A, term legal representative is wider than legal heir. B, all legal heirs include legal representatives. C, legal heirs and legal representatives constitute a distinct and separate group of persons. And D, both terms are synonymous and denote common group of persons. So, what happens here? Legal representative. The examples for legal representatives could be executors, administrators, legal heirs also. That is why when it comes to LRs and legal heirs is a broader term. It includes even legal heirs also, and it includes executors, administrators, different persons are there. Under that definition, legal representatives, as per CPC definition, it includes such persons who intermeddle with the estate of the deceased, who represent the estate, right. Hence, A is the correct answer. Hello Vinny, good evening. Hence, A is the correct answer. Next one, sixth question. Pending proceedings in a representative suit, the dispute is settled between plaintiff and defendants. They jointly filed an application to record settlement which was allowed. Suit was decreed in terms of the settlement. Is there any procedural irregularity? Okay, so this is a representative suit. Many persons' interest will be there in the representative suit. Here what has happened? The plaintiff and the defendant, they filed an application where it was allowed. Is there any irregularity? For any kind of settlement, compromise or anything, you need to obtain the leave of the court. Settlement, even for settlement, compromise by way of settlement. Hence, there is some irregularity, procedural irregularity is there. The court should have granted leave to settle. Court has to overlook this proceeding. First it has to permit and then they have to settle. Directly they cannot settle. Hence, that is a procedure irregularity. Next question, seventh. The right available to a mortgagee in a usufructuary mortgage for recovery of mortgage money is A, suit for redemption, B, suit for forceful possession, a suit for foreclosure, C, a suit for accounts, and D, by retaining possession. Usufructuary mortgage, one of the key important feature of this usufructuary mortgage is that no personal undertaking is there, and apart from that he can recover the mortgage money. How does he recover the mortgage money? By retaining the possession till his interest or a principal is paid, or partly interest principal is paid, depending upon different permutation and combination. That is why D, by retaining possession. Usufruct, he can enjoy the usufructs, whatever income he derives from the property. Eighth question. Doctrine of election under section 35 of the Transfer of Property Act is based on which among the following principles? A, principle of nemo dat quod non habet. B, one cannot approbate and reprobate. C, principle of estoppel, and D, principle of equity. So, what does doctrine of election mean actually? It says if one professes to transfer the property of someone else and thereby he gives certain benefits to him, the owner who is there, whose property is being transferred, if he is accepting the benefit, he has to transfer that, he has to abide by that, the other person, one who is transferring his commitments. So he cannot accept the benefit, and he cannot also say that he won't transfer. So he cannot blow hot and cold at the same time. He cannot approbate and reprobate. He can accept benefit, and he cannot reject the whatever obligation he has. He cannot do that. That is the basic of the principle of doctrine of election under section 35. It is 8b. Yes, Vinny, correct. Next question, 9th question. Which among the following is not correct in relation to substituted performance of a contract under section 20 of the Specific Relief Act? A. Person who suffers due to non-performance of a contract is entitled to invoke the above provision. B. It cannot be invoked unless 30 days notice in writing is given to the opposite party. C. A person who exercises the option of substituted performance is entitled to seek specific performance of the contract. And D. Exercise of substituted service will not prevent such person from seeking compensation from party in breach. Yes. What is the answer here? Which is not correct? When it comes to substituted performance, so these are those two kind. This is the alternative relief. Substituted performance is alternative to substituted performance is alternative to specific performance. If you obtain this, you cannot obtain specific performance. If you obtain specific performance, you cannot have substituted performance. That's why one who is exercising the option of substituted performance is not entitled to seek specific performance of a contract. That's why C is the correct answer. Next one, 10th question. A suit for mandatory injunction under section 39 of the Specific Relief Act is dismissed, holding that the plaintiff is not entitled for the discretion. Can the plaintiff sue for damages? A. No, in the light of section 40 subsection 3 of the above act. B. Yes, in the light of section 39 subsection 2 of the act. C. No, in the light of section 41 of the act. And D. Yes, in the light of section 39 1 of the act. So what is the answer here? When the suit is dismissed, again a separate suit for damages cannot be filed. That is under section 40. See, you cannot go for two separate claims. He could have asked this in the same suit where mandatory injunction was there, and when he had asked, even the court had rejected that claim. Again, for separately for damages, he cannot file a case. So it is A is the correct answer as per section 40 subsection 3 of the act. Next one, 11th question. A took a building on rent from B, terminable by giving 1 month notice from either side. C, an unauthorized person gives notice of termination to A. B ratifies the act of C. Is the ratification valid under the Contract Act? If so, why? Regarding agent and principal relationship here, it is A, because this cannot injure the third party. Here what is happening? A took a building on rent from B. So A is tenant on rent, B gave 1 month notice from either side. C, an unauthorized person. C, an unauthorized person. Okay. C, an unauthorized person gives notice of termination to A. So, C is giving some notice to A to terminate. Although C is not the act, he may be the agent or not, but B is saying that he is ratifying the act of C. So, is the ratification valid under the Contract Act? Actually, the principal can ratify the act of the agent, but when such ratification is which is injuring the third party, then such things can't be ratified. Okay? So, A is the correct answer. Next, 12th question. Which among the following is not a mandate for applying section 92 of CPC? A, suit must relate to a trust created for public purpose. B, there must be an allegation of breach of trust. C, suit must be filed by any statutory authority. And D, relief claimed must be one or other mentioned in section 92. Okay, so what is the answer here? It is not a mandate. So, section 92 is for the public purpose. When there is an allegation of breach of trust, it can't be filed by any statutory authority. Okay, either Advocate General or any two persons, they have to file who are having interest in that trust. And the relief claimed must be one or other mentioned in section 92. This is true. So, only this statement is wrong. Hence, C is the correct answer. This is not a mandate under section 92. 13th question. A suit with leave of the court is instituted at a place where one among the three defendants reside. Other defendants after appearance raise objection that they do not reside, work or carry on business with the jurisdiction of that court. Is the objection sustainable? Sometimes what happens when too many defendants are there? If the suit is filed in residence or the place of work in that jurisdiction, other defendants may object. So, either you have to take the consent of other defendants, or if they acquiesce, I won't say consent, but if they acquiesce in such suit, or if you obtain the leave of the court. If you obtain the leave of the court also, then what will happen? Even if the object, that's not this one, it's not sustainable. Objection is not sustainable because of which provision? Because of in the light of section 20B of CPC. Okay. Next one, 14th question. A judgment debtor is brought under arrest in execution of a decree for payment of money. Which among the following is the duty cast on the execution court? A, enquire from the judgment debtor whether he has the means to pay the decree debt. B, inform the judgment debtor that he is entitled to apply to be declared as insolvent. C, enquire whether he can offer immobile property as security for release. And D, enquire whether he has solvent sureties so that he can be released on bail. So, in this under in question number 14, it is the duty of the executing court that he can apply to be declared as insolvent. Then some of his, yes Meera, I am getting your answers. Okay, you had mentioned as 14B, Vinny also, I am getting your answers. I don't know, but immediately I am getting, after some time I am getting, like when I am in okay. So, what is the answer here? Here it is the B, inform the judgment debtor that he is entitled to apply to be declared as insolvent. Next, 15th question. An advocate commissioner appointed by court at the request of the plaintiff conducted local inspection with a notice to defendant. Defendant filed objections to the report. In the trial, advocate commissioner was not examined. After trial, on request of plaintiff, report was marked by court as Exhibit C1. Is the procedure correct? A. No commissioner has to be examined. B. Yes, commissioner being an officer of court need not be examined. C. No, plaintiff has to examine the commissioner. And D. Yes, since the report forms part of the record and it is the duty of the party who files objection to establish his objection. What is the answer here? Court Commissioner report as per Order 26, Rule 10. It has to be supported with the report. And when this is the case, the report forms the part of the record and it is the duty of the party who files objection to establish his objections. So, report was marked. D is the correct answer. Yes, Mir. It is 15D. Next one, 16th question. A landlord obtains an order of eviction under section 11(4) of the Kerala Buildings Lease and Rent Control Act. Landlord fails to reconstruct within the time fixed. Which among the following is the relief that cannot be granted to the tenant on his application? A. To direct the landlord to pay the rent which tenant had to pay for another building he is occupying consequent to eviction. B. In appropriate cases to put the tenant back to possession. C. Pay fine not exceeding ₹500. D. Issue direction for reconstruction. So, what can he do? Which cannot be granted to the relief, or to which relief cannot be granted to the tenant. Reconstructing, regarding the reconstruction. It is A. To direct the landlord to pay the rent which the tenant had to pay for another building he is occupying consequent to eviction. Next one, 17th question. In which among the following circumstances a memorandum of title deed in a mortgage by deposit of title deed is liable to be registered? A. When the memorandum evidences the details of the property mortgaged. B. When the mortgage is created by the memorandum of deposit of title deed. C. When the mortgagee undertakes to retain a portion of mortgage money to be repaid later. And D. When mortgage by deposit of title deed is created in an area outside the notified town. See, DTD we say, deposit of title deeds. When is it liable to be registered? When should it be registered? Because just the delivery of the possession itself is sufficient. But when is the requirement of the registration of such memorandum of deposit, memorandum of title deeds? So, when it is reduced into writing, when the mortgage is created, so only if it is just, if you are creating the mortgage just by delivering the possession, delivering the title deeds, then no such registration is required. But when it is reduced into writing in the form of a memorandum, then necessarily it has to be registered. Hence, B is the correct answer. 18th question. Under CPC, in one situation, the contract of engagement of a lawyer by the party to a suit will be deemed to continue even after the death of that party. Which is that situation? A. Till the pleader inform the court about the death of the party. B. Till the legal heirs engage a new lawyer. C. Till an application for implement of legal heirs is filed. And D. Till the legal heirs are brought on record. So, what happens here? This is a question regarding impleading of legal representatives. Otherwise, the suit gets abated. Question under Order 22. What is the duty of the pleader? Till when? Even if his client dies, still the pleader is having the duty to inform about the death of that party. So, what is the correct answer here? It is 18. Yes, Vinny has answered 18A. Till the Pleader inform the court about the death of the party. Next one, 19th question. Which among the following is the consequence of rescission of a voidable contract? If you resign, if you cancel the contract, voidable contract, what is the consequence? A. Party residing the contract, if he has received any benefit thereunder, should restore such benefit. B. Party residing will be under an obligation to continue to perform his part. C. The party residing will be entitled to ask the opposite party to perform his part. And D. None of the above. What is the option here? 19. Yes, it is party A. It's A. A is the correct answer. Party residing the contract, if he has received any benefit thereunder, he should restore such benefit. Restoration, because no person can benefit at the expense of the others. Benefit should be restored. Next one, 20th question. In a proceeding under section 138 of Negotiable Instrument Act, the trial court ordered interim compensation under section 143A of the Act. The drawer of check was acquitted after trial. What should be the consequential order relating to interim compensation? A. The court shall direct that interim compensation shall be repaid by the complainant within 30 days. B. The amount paid will be repaid only after appeal period is over. C. The court shall direct the complainant to repay the amount of compensation with interest at bank rate within 60 days. And D. The interim compensation will stand forfeited. What happens here? Twenty it is C. 20 answer is C. The court shall direct complainant to repay the amount of compensation, because here it became ulta. He received the interim compensation, but later the accused got acquitted. Then what will happen to that interim compensation? That's why the court shall direct the complainant to repay the amount of compensation with interest at bank rate within 60 days. Okay. So, the next question, 21st question. Which among the following is not contemplated under section 89 CPC? A. Mediation, B. Judicial settlement, C. Conciliation, and D. Negotiation. What is not contemplated? What is not given under section 89? Yes, it is. Negotiation is not one of the modes of the alternate dispute resolution mechanisms. Others are true. Mediation, even arbitration is one of the mode. Arbitration, mediation, through Lok Adalat. Right? Yes. So, next one, 22nd question. What is the legal status of a finder of lost goods? A. Trustee, B. Bailer, C. Bailee, and D. Pawnee. It means the person who finds the goods, who is the finder of the lost goods, he will be having the responsibilities and he will be having the rights as that of a bailee. Yes, it is bailee. C is the correct answer. 23rd question. Under the Contract Act, what is an advertisement inviting tender? A. An invitation to offer, B. An offer, C. A standing offer, D. None of the above. Standing offer is something where the offer is kept open for a long period of time. So whenever the party wants to order, by accepting this, he keeps on placing the orders. That is standing offer. But this one, advertisement inviting tender, this is in the nature of an invitation to offer. A, offer and invitation to offer, like how display of goods, like that. Even an advertisement for notification, your examination notification, timetable in airport, railways, all these are examples of an invitation to offer. 24th question, in what type of commercial instrument under the Negotiable Instrument Act the drawer is both debtor to one and creditor to another? A, hundi, B, promissory note, C, bill of exchange, and D, check with endorsement. So what happens here? The drawer is creditor to one, he is a debtor to another person. In which kind of instrument? It's a bill of exchange, right? Because here he is the drawer of the bill. He says to his debtor that if my creditor comes, then give that amount to him. So this drawee is a kind of an acceptor also. So in the bill of exchange, C, we can find that the drawer is both the debtor to one and creditor to another. Next, 25th question, what is the legal status of a contract prohibited by law? A, void contract, B, voidable contract, C, illegal contract, and D, ratifiable contract. These are given under section 23 of Indian Contract Act. Of course, it is void, but more than that, they are, which is a prohibited by law, that becomes illegal. The key answers, they have given it as an illegal contract. Okay, of course, it is a void contract also. Void agreement, sorry, there is a difference between void agreement. That is why this is not a void contract. They are from the beginning itself, they are the nature of agreements. If it is a void contract, then what will happen? Initially they are proper, but later they turn out to be void one. That is why the best option is illegal contract. 26th question, under section 34 of Specific Relief Act, what is the prerequisite? What is the prerequisite for filing a suit for declaration of status or right? A, he must be entitled to any legal character or to any right to property. B, he must be entitled to any legal or statutory right. C, he must be a person whose legal status is offended. D, none of the above. Essential ingredient for filing a suit for declaration under section 34. A person should be asserting a particular legal character or to any right to the property. Okay, that is why A is the correct answer, whereas the other person is denying that legal character or denying his right to property. Then you can go to the court and ask for please declare my status or please declare my right. 27th question, in which among the following instances the property of a receiver appointed under order 40 CPC can be attached and sold in execution? A, when he commits delay in payment of dues. B, when he fails to hand over charge. C, when he occasions loss to property due to his willful default or gross negligence. D, when the subject matter is alienated by receiver. Order 40. The property of a receiver. Receiver is appointed, it's a drastic measure because the two persons are fighting. So that whatever the receivables from the property are there, he can receive it. But when can this receiver's property be attached and sold? He will be punished for being appointed as receiver. When is that circumstance? It is because of his acts, he commits loss, he occasions loss to the property due to his willful default or gross negligence. Okay, so C is the correct answer under order 40 CPC. Next one, 28th question. Parties interested in the decision on a question of fact or law enter into an agreement to refer such matter to court and to comply with the decision of court. What is the name given to such proceeding? So this is the case where they agree and say that we have one question or fact which has to be decided, question of fact or question of law. Let's refer this question to the court. So there is no such dispute between them, just they have to get it clarified by the court. So what kind of suit is this? Yes, it is a special case under order 36. Yes, Vinny and Mir, both you are answering correctly. In 29th question, under section 11 of Rent Control Act, a tenant engaged in any notified essential service is exempted from eviction under the act. What is the statutory exception to that? A, where the landlord has no other building of his own. B, where landlord himself is employed in such notified employment. C, where the landlord bona fide require the building for his own use. And D, where landlord himself is engaged in such notified employment and he requires the building for his own occupation, which is a notified essential service according to Kerala Rent Control Act. It is D. Okay, D is the correct answer. Next one, 30th question. Under the Contract Act, a guarantee which extends to a series of transactions is known as A, perpetual guarantee, B, unlimited guarantee, C, continuing guarantee, and D, limited guarantee. Guarantee for a series of transactions. Yes, it is always known as, it's a continuing guarantee. C is the correct answer. Okay, if you have attended yesterday's class, you would be knowing the same question, same principles, but question is asked in a different manner. 31st question, see here, might and ought principle relates to section 11 CPC, section 10 of CPC, section 47 of CPC, and D, section 151 of CPC. It is nothing but the constructive res judicata. Section 11, explanation 4, section 11 of CPC. 32nd question. A has a cause of action against B to sue for malicious prosecution. Can it be assigned to another for consideration? A, yes, there is no legal embargo. B, no, it amounts to a contract of champerty. C, no, it is hit by section 6E of Transfer of Property Act. D, yes, it is a voidable contract. Suing for malicious prosecution. So can this be assigned? Can this be transferred for consideration? What is section E? It is mere right to sue. Mere right to sue. It is coming under section 6E, which says such properties cannot be transferred. Okay. So Shampati and maintenance agreements, they say, supporting, I will give you money to sue another. Did you get it? Shampati. I am having revenge towards some person, so I'll provide you with all whatever money, whatever requirement, so that you can maintain a case against them. That is Shampati agreements, which is against public policy. That Shampati agreements contract, they come under, they are against public policy. Section 23, Indian Contract Act. This one is Section 6E, mere right to see. Hence it is not transferable. 33rd question. Company as referred to in section 141 of the Negotiable Instrument Act does not include A, a firm, B, any corporate, C, an association of individuals, D, joint Hindu family. 141. It is joint Hindu family, section 141. Company includes firm, association of individuals and body corporate, but it does not include joint Hindu family. 34th question. In relation to invasion into enjoyment of property, which among the following is a ground for refusing perpetual injunction under the Specific Relief Act? Where defendant is the trustee of the property, where it is necessary to prevent multiplicity of proceedings, where compensation in terms of money would afford adequate relief, and the fourth one, where there is no standard for ascertaining actual damage caused. Under which ground you can refuse perpetual injunction? This is a question under section 41 of Specific Relief Act, where injunction, perpetual injunction cannot be granted. So if compensation in terms of money would afford adequate relief, then it's a grant for refusing perpetual injunction. Next, 35th question. Any order under section 47 CPC can be reversed or modified only if A, there is any error, B, there is any defect, C, there is any irregularity in proceedings, and D, if any of the above has prejudicially affected the decision of the case. When section 47, under an order which has been given under section 47, it can be reversed. This is coming under section 99A of Code of Civil Procedure. So when if any of the above has prejudicially affected the decision of the case, means due to error, defect or irregularity, if it is affecting the case prejudicially, then it can be reversed or modified. Otherwise, just because of it's erroneous or defective, for that reason such orders can't be modified. What's a punem mortgage? What do you mean by punem mortgage? A, multiple mortgages by mortgagee. B, second mortgage of the same mortgage property by the mortgager. C, mortgage of the same mortgage property by the mortgagee. D, mortgage of a multiple properties by the mortgager. A is mortgaging his property to B, the same property. This is the first mortgage. And A is mortgaging the same property to C. This is the punem mortgage, or the second mortgage of the same mortgage property by the mortgager. Once he will be mortgaging to State Bank of India. Second time he is mortgaging his same house to Canara Bank. That's the example of punem mortgage. Next, 37th question. Which among the following is not true in relation to vested rights? A, vested rights are not subject to any condition, and if at all there is a condition, it is a specified certain event. B. Vested rights are heritable and alienable. C. Vested rights are revocable after transfer. D. Vested rights are not defeated by the death of the transferee before acquiring it, which is not true. Of course, they are not subjected to any condition. They are heritable and alienable. They are not defeated by the death of the transferee before acquiring it. Hence, this one is wrong. They are revocable after transfer. This is an incorrect statement. It can't be revocable. Hence, this is not true. 38th question. Among the following, in which case a person detained in civil prison in execution of a decree cannot be prematurely released? A. On the decree passed against such person is fully satisfied. B. On the request of the family members of the judgment debtor. C. On the deposit of the amount mentioned in the warrant with the officer in charge of the civil prison. D. On failure of decree holder to remit subsistence allowance. A person has been arrested for not properly paying the money for execution. He has been arrested and kept in detained in civil prison. Can he be released in civil prison because of all these reasons? But only one reason is there due to which he can't be released, that is on the request of the family members of the judgment debtor. In all other cases, if it's fully satisfied, if he deposits the amount, or the decree holder fails to give subsistence allowance, he can be released. Of course, he can be released only on the request of decree holder, but if decree holder is not paying subsistence allowance, he will be released, or if he pays the amount, even then he will be released, but not on the request of the family members. 39th question. Summons ordered from a court is returned with an endorsement of serving officer on the ground that defendant refused to accept the summons. The court is bound to examine the serving officer under Order 5, Rule 19 of CPC. If the court has doubt regarding the endorsement, the serving officer has not verified it by an affidavit. C. The court is informed that the address of defendant is wrong, and D. None of the above. Order 5, Rule 19. It is 39. It says the serving officer has to be examined when compulsorily, when the summons has been returned with an endorsement that the defendant refused to accept it. In such a case, if that return is not verified by the affidavit, then he has to be examined. The court is bound to examine the serving officer. 40th question. A, for natural love and affection, promises to give his son B a sum of ₹1 lakh. A, reduced that into writing and registered it. Is it a valid enforceable contract? Which is the relevant section? A, valid contract, section 25 of Contract Act. B, voidable contract, section 24 of Contract Act. C, void contract under section 26 of Contract Act. And D, illegal contract under section 27 of the Contract Act. So, when a person is promising, he is giving as a way of a gift ₹1 lakh. What is the consideration for that? Nothing. But that will be coming as an exception, where out of natural love and affection, where such thing is being in writing and it is being registered. Okay, that's why A is the correct answer. It's a valid contract under section 25 of the Contract Act. So 40 questions were completed, which is regarding civil law. Then we'll move on to part B. The same question was asked in 2022 question also, right? So it's very necessary to solve previous year question paper, and we are solving the same thing. There could be some discrepancies somewhere here and there, but please read thoroughly of all these sections or whatever we deal with. The concepts, please read them properly, because they are the probable questions in your upcoming 2023 examination also. 41. Estoppel is a rule of procedure, rule of evidence, C, rule of substantive law, and D, rule of convenience. It is nothing but rule of evidence, estoppel. Yesterday we had seen section 34 as a rule of evidence in yesterday's class question, in 2022 question. So somehow like this only the questions are given. 42nd question. Which among the following is the essential ingredient of section 30 fourthly of IPC? Yesterday with respect to this, one illustration was given. This time it is only regarding the concept. So we can relate many questions together. So the options are intention to cause death, B, knowledge that the act is imminently dangerous and that in all probability it will cause death, C, intention to cause bodily injury which is sufficient in the ordinary course of nature to cause death, and D, intention to cause such bodily injury as the offender knows is likely to cause death. So here as per section 300, fourth, it is knowledge that the act is imminently dangerous, that in all probability it will cause death. The illustration was firing in a mob. Just if he points towards the sky and if he fires also, if it causes death, that is a murder only under section 300. 43rd question. Which among the following is incorrect in relation to issue estoppel? So we have different types of estoppel, right? When it comes to issues, estoppel relating to issues, A, it applies only if both proceedings are criminal proceedings. B, where an issue of fact is tried by competent court on former occasion and finding is rendered, it would constitute issue estoppel. C, the estoppel is against reception of evidence to disturb an earlier finding of fact. D, issue estoppel will act as a bar against trial and conviction of same accused even for a different and distinct offence than the first one. So what is incorrect? It is D. Issue estoppel will act as a bar against the trial and conviction of same accused even for a different and distinct offence than the first one. 44th question. One person enticed A from his home to be offered in sacrifice to a goddess. Okay? Which among the following is the offence committed by that person? Section 365, section 364, section 359 and section 363 of IPC. 44th question. This is a kidnapping, case of kidnapping or abducting in order to murder. So what will that become? It is B, that is section 364 of IPC. 45th question. In the course of interrogation of an accused in police custody, he confesses. This is a confessional statement from here to here. So please read this. So here the murder was committed by me using a sharp knife. After that I washed the knife in the pond near the temple. I have hid the knife beneath the culvert. If I am taken there, I will show it to you. The knife is recovered from the spot as shown by accused. To what extent the extracted portion of the confession is admissible in a criminal trial? A, the entire extracted portion. B, from here to here. Where is that? After that. here. One is saying from after that to show it to you. Another says I have hid from here to here. D, none of the above. Which one is admissible? The question under section 27. This is the question under section 27 of our Indian Evidence Act. That's why it is C. Only from the discovery. It is also known as the discovery statement. So, only this portion is admissible. 46th question. In a trial for committing murder of A by B, PW2 gave evidence that few days prior to the incident, he saw A and B consuming liquor in a bar and thereafter they went together. PW2 did not see A thereafter. What is the most logical deduction the court can arrive at? A, the last seen theory can be applied. B, B might have murdered A. C, B in all probability might have murdered A. D, A and B were friends. It just gives the logical deduction that A and B were friends, nothing more than that, nothing like murder, last seen theory. Only this can be arrived at, that together they were having drink. 47th question. A woman revenue officer tries to enter property of X to effect attachment and execution of revenue recovery proceedings. When this is disclosed, X puts the officer by hand. Which among the following offences committed by X? Under 354, 353 and 355 and 352. Yes, Mir and Vinny. This is a case where assault or criminal force by a assault or criminal force to deter a public servant from discharging their duty. As a revenue officer is a public servant, to discharge her duty, they are pulling by hand. We can say that B is applicable. Section 353 IPC. Next 48th question. The object of examining the accused under section 313 CRPC. Why do we examine the accused under section 313? Because explain personally his defense, explain the allegations brought out against him in evidence, answer the charges framed against him. To personally explain the circumstances appearing in the evidence against him. It is nothing but D. Personally explain the circumstances appearing in the evidence against him. 49 question. Who among the following is entitled to invoke the power under section 321 of CRPC? Section 321 deals with withdrawal from prosecution. So, who can do that? Which all officers can withdraw from the prosecution? It is either public prosecutor or assistant public prosecutor in charge of that case. Fiftieth question. The presumption under section 112 of Evidence Act can be displaced by husband by establishing which among the following fact? A, parties had no access during the relevant period. B, husband was abroad for a long period. C, husband was temporarily disabled for a long period. And D, wife was abroad continuously for a long period. Okay, so what is the answer here? This is regarding the paternity. So, when a person, regarding the birth of the child during the subsistence of the marriage or even after the 280 days of the dissolution of the marriage. So, that is a conclusive proof, but it can be such presumption can be replaced by saying that the parties had no access during the relevant period. Next 51 question. In the course of trial of an offence under section 324 IPC, the doctor who had examined the injured and issued wound certificate deposed that the injury was sufficient to cause death. What is the option available to the magistrate? A. Address the Chief Judicial Magistrate for necessary action. B. Stop the trial and order further investigation. C. Commit the case to Sessions Court for trial. D. Request the Sessions Judge to exercise power of suo motu revision. Hmm? 51. It is C. Under section 209. Can commit the Sessions Court for trial. Yes. 52nd question. So we have still 50 questions to go. So I'll just speed up. Okay. I'll be browsing through the. It's already 10:15. So is the protection applicable to a judge under section 77 under general exception? Applicable to a magistrate. So whether judge and magistrate are same, if you have to see. If so, under which provision? A. No, yes in view of section 19. C. No in the light of section 22. And D. Yes in the light of explanation under section 77. It is yes. As per the definition of judge, even magistrate is included, but who is empowered to give sentence? The magistrate who is just for the purpose of recording statement and all, he is not considered to be a judge, but one who is entitled to give punishment, that magistrate is known to be a judge. 53rd question. Mandatory death sentence for committing murder by a person serving life sentence under section 303 IPC was struck down by Supreme Court in which case? R.C. Cooper, B. Bachchan Singh, C. Aruna Shanbhag versus D. Mittu versus State of Punjab. It is in D. Mittu versus State of Punjab. 54th question. Under section 132 of Indian Evidence Act, answer given by a witness in cross-examination can be used in one type of prosecution. Which among the following is that? A. Prosecution for giving false evidence by such answer. B. For malicious prosecution. C. In a contempt of court procedure. And D. In a proceeding for defamation. It is A. Prosecution. So only if yesterday we had seen 132, 147 and all, if a person gives such a statement which may incriminate him to a particular prosecution also, for that he may not be prosecuted, but if he gives false statement, on that ground he may be prosecuted. So only that kind of prosecution is permitted. 55th question. Oral evidence regarding contents of electronic evidence are not relevant under section 22A of Evidence Act. It has an exception. Which among the following is it? A. If electronic records are lost and not available. B. If electronic records are not produced from proper custody. C. If genuineness of electronic evidence produced is in question. And D. None of the above. It is C. If genuineness. Yesterday we got a question about only section 22. Today it is about section 22A. Here when genuineness of electronic evidence produced is in question. 56th question. Classic decision in Privy Council in P. Kottaya and other versus King Emperor relates to which provision of Indian law? This is regarding our section 27 of the Indian Evidence Act regarding discovery statement. How much portion is relevant? Okay. Hello Aarti. I think now you joined. Next 57th. Does the prohibition against the privileged communication between lawyer and a client under section 127 of Indian Evidence Act extend to this clerk also? Extend to his clerk also. A. Yes under section 127. No under section 126. Yes under section 123 and no under section 122. 57th, yes under section 127 of the Evidence Act. Next one, 58th. Which provision of law provides for declaring a witness as hostile? A. Section 154 CRPC, B. Section 154 Evidence Act, C. Section 150 of CRPC, and D. Section 150 of Evidence Act. It is 58th. 154 hostile witness. Question by party to his own witness. Section 154. Then 59th question. Can a district magistrate grant an order of injunction? See, this is a district magistrate DM who is having constitutional authority. Even can he grant an order of injunction? If so, which provision? No, it's in the domain of civil code. B, yes, under section 142 CRPC while conducting enquiry under section 133 CRPC. Yes, under section 143 CRPC while conducting enquiry under section 144 CRPC. And D, yes, under section 144 while conducting enquiry under section 133 CRPC. It is B, under section 142 CRPC and also enquiry under section 133 CRPC. B is the correct answer. 60th question. Opinion on the relationship between the two persons expressed by conduct by a member of the family and who has special means of knowledge in that capacity is not a sufficient proof in which among the following proceeding. A, in a proceeding for defamation, B, to prove marriage in any proceedings under the Divorce Act, C, in a proceeding under the Indian Succession Act, and D, in a proceeding for maintenance under section 125 CRPC. So, question under section 50. That's why which is not a sufficient proof. So, this is to prove marriage, this is not a sufficient proof. Next, 61st question. Which among the following is not a privileged communication? So, please read the options. What is the correct answer here? It is D, right? 61st question. Communication between husband and wife during marriage in a proceeding under section 498 of IPC. D is the correct answer. 62nd question. A surgeon, after checking the reports of his patient, informs in good faith for the benefit of that person that he may not survive. Patient suffers a shock and dies. Has this surgeon committed any offence? Which is the provision of law applicable? A, no in view of section 93 IPC, B, yes in view of section 95 IPC, C, yes in view of section 92 IPC, and D, no in view of section 88 IPC. This is a question regarding communication made in good faith. Communication made in good faith. Then what is the answer? That's why he has not committed any offence under section 93 of IPC. 63rd, victim's right of appeal under proviso to section 372 CRPC does not extend to which among the following? A, for enhanced sentence, B, acquitting the accused, C, convicting for lesser offence, D, imposing inadequate compensation. Right of appeal. It's not applicable to enhanced sentences. For rest of the thing, victim can appeal. So, naturally, actually it is the state which is going for appeal, but even victim is also getting a right to appeal, but not for enhanced sentence. Not with respect to enhanced sentence, he cannot go for an appeal. 64th, the concept of, yes, it is 377, yes. The concept of letter rogatory is embedded in which among the following provisions of CRPC? A 166A, 156 CRPC, 164 CRPC and 167 CRPC. Sixty-fourth, letter rogatory comes under 166A. Even in yesterday's question we had seen, right? Letter of request to competent authority for investigation in a different country outside Indian courts. 65th question, under what all circumstances an unmarried illegitimate child who has attained majority entitled to maintenance under section 125 CRPC? Whether legitimate or illegitimate, that does not make a difference, but married and unmarried and majority, that may make a difference. But if she is by reason of any physical or mental ability, mental abnormality or injury, is unable to maintain herself, then she is entitled to maintenance. Married daughter, although she has attained majority also. Sorry, not married, unmarried daughter. One injury is also included here, even injury. 66th question, the principle of vicarious liability is embedded in which among the following offences? Section 107, Section 153 IPC, Section 120B IPC and Section 34 of IPC. Vicarious liability. Section 34 is there, Section 149 is there. So D, Section 34 of IPC. 67th question, what is the evidentiary value of a retracted confession of an accused? A, it cannot form basis of conviction. B, it can form basis for conviction even if not corroborated on material aspects. C, can form basis of conviction without corroboration if found to be perfectly voluntary, true and trustworthy. D is weaker than direct evidence. ಏನಾಗುತ್ತೆ ಆವಾಗ? So what will this become? Retracted confession can become basis of conviction. Retracted confession means first I say I have done a mistake, then I say no, I haven't done the mistake. That's the meaning of retracted confession. Although if it is retracted also, it forms the basis of conviction even without corroboration if it is meeting this condition of being voluntarily given, if it is true and trustworthy. 68th question, A confesses to be in a drunken condition that he has committed theft in the house of C. This was confirmed in evidence by B. Is this evidence relevant in trial? A, no, since A was in a drunken condition. B, yes, in view of section 29 of Evidence Act. C, no, in view of section 26 of Evidence Act. D, none of the above. So 68, what does it say? In a drunken condition. So this is section 29. See, if a confession is taken under a promise of confession otherwise relevant, they say under section 29, even in promise or secrecy in a drunken condition also, such event also, if they give the confession, then it would be relevant. 69th, the term mutually satisfactory disposition in CRPC relates to a plea bargaining with proceedings under section 125 CRPC, C, pleading guilty, D, trial of matrimonial offences. Mutually satisfactory disposition is something which we find in the plea bargaining from section 265A. to 265L, plea bargaining. 70th question. So we have 30 more questions to go. Please read this question. what is the, no, not tired, it's a very lengthy question, no? So thank you for asking, but this is a case where a cheating case has been lodged, but the accused is saying that he was about to deliver, but it met with an accident, that's why he couldn't deliver. Actually, it was he had offered to sell that car, and had also obtained the consideration for that. So what is the logical conclusion? Why did he not deliver the property? Here we can say that complainant failed to establish that the accused had an intention to cheat. If he says in 313 statement, compensation for damages and all, if that could be given, then D. 71st question. A person is working on a machine with necessary safety precautions. A portion of the machinery breaks off and injures another employee. Which statutory protection is available to him? This is a case of an accident in doing a lawful act. Section 80 is applicable, Section 80 IPC. 72nd question. An adult male peeps through the keyhole of the washroom while a woman is bathing. Which offence is committed by him? A. Stalking, B. Voyeurism, C. Outraging the modesty of a woman, and D. Social harassment. It is, yes, which was added by of Criminal Amendment 2013 Act, Section 354C, voyeurism. 73rd, which authority is competent to commute death sentence under Section 54 of IPC? A. State government, B. Union government, C. Governor of a state, and D. Appropriate government. Third. It is, yes, appropriate government can commute death sentence. 74th question. Which among the following is not an ingredient of Section 304B of IPC? A. Death caused by bodily injuries or burns. B. Occurs within 8 years of marriage. C. Deceased was subject to cruelty or harassment. D. Such cruelty must be in connection with demand for dowry. 304B of IPC. Here it would have been occurred within, if 7 years of marriage, this would be correct. This would be an ingredient. But as they are given 8 years, hence this is not an ingredient. Rest of the things are ingredient. Death caused by bodily injuries, subject to cruelty or harassment, in connection with the demand for dowry. So all these are true. 75th question. One person owns a ferocious dog. It is not properly chained. Consequently, it injures the neighbor. What is the offence committed? This is with respect to Section 289 of IPC, which says negligent conduct with respect to an animal. Negligent conduct with respect to animal. 76th question. Which among the following does not amount to personation at election? Votes in the name of another person, votes in fictitious name, votes once again after himself voting earlier. D. Proxy voting under authorization, which does not amount to personation at election. It is D, right? Proxy voting under the authorization. 77th question. In the course of extortion, victim is put to fear of instant death. What is the offence? When theft becomes robbery, when extortion becomes robbery. So it is nothing but a robbery under Section 390 of IPC. Yes, Mir. Correct. Then 78th. An information regarding commission of a non-cognizable offence is disclosed to the station house officer. What is his duty? What can he do under section 155? Register the crime and investigate, seek permission of court to investigate, register the crime and seek permission for the investigation, record the substance of information in a book and refer the informant to the magistrate. It is D as per section 155. 79th question. What is the ultimate duty of the investigation officer conducting investigation in a cognizable offence? A. File report regarding exclusion of any person from array of accused. B. File a report under section 173(2) CRPC. C. File report under section 172 CRPC. And D. None of the above. What will it happen? It is B. You can file a report under section 173(2) of CRPC. Next one, 80th question. Which among the following is correct? A. Sessions Court can take cognizance of a case only when it is committed to. B. Sessions Court may at its option take cognizance without committal. C. Unless otherwise provided by code or any other law, Sessions Court can take cognizance of cases only when it is committed to it. And D. All the above are wrong. This is a question under section 193 CRPC. It is, this is correct, only when it is committed to it. Yes, for this one, no, Sessions Court cognizance. In defamation they can take. Yes, exactly. Then 81st question. Yes, part B is also over, 40 questions. Then we are moving on to part C. So it's a very easy this one, provided you know some current affairs and constitution. So name the woman who was the judge of the Supreme Court of India as well as the governor of a state. It is Justice Ruma Pal, Justice M. Fatima Bibi, C. Justice Leela Seth, and D. Justice Anna Chandy. She was also the first woman judge of the Supreme Court of India. It is none other than Justice Mira Sahib Fatima Bibi. 82nd question. What is the meaning of maxim ubi jus ibi remedium? For breach of justice, there is a remedy. Whoever is just gets remedy. Where there is right, there is remedy. And D. Justice cannot exist without remedy. (82) Yes. Where there is right, there is remedy. C is the correct option. Next, 83rd. The concept of free legal aid takes its root from which article in the Indian Constitution? A. Article 30, B. Article 38, C. Article 39, and D. Article 39A. It is none other than Article 39A, right to free legal aid. Directive principles of state policy. 84th. The only writ which is sustainable against a private individual is mandamus, certiorari, prohibition, and C. habeas corpus. Yes, it is nothing but the habeas corpus, C. Okay, this is a kind of just logical reasoning they are asking. So, chair has 4 legs. Chair is having 4 legs. Even animal has 4 legs. It means that chair is an animal. So, what kind of reasoning this is? Induction reasoning, syllogism, illogical reasoning, and absurd reasoning. This kind of reasoning is known as syllogism. 86th question. Statute provides that senior citizen is liable to be maintained by a close relative like son, daughter, grandchild, brother, sister, etc. The question that arose is whether daughter-in-law is liable to maintain, etc. So, etc. means which all persons. So, which rule of interpretation will apply? Nocitor associs, beneficial interpretation, ejus dem generis, and D, golden rule of interpretation. It is C, ejus dem generis. It means of the same kind, of the same kind. Next, 87th question. Right to privacy was considered elaborately by a constitution bench of the Supreme Court. Which is that judgment? A. Menka Gandhi versus Union of India, B. Indian Young Lawyers Association versus State of Kerala, C. Olga Tellis versus Union of India, and D. K.S. Puttaswamy versus Union of India. Right to privacy was discussed, a very famous judgment which is nothing but Justice K.S. Puttaswamy versus Union of India. He himself was the justice, K.S. Puttaswamy. 88th question. Voir dire is commonly related to which among the following in a judicial proceeding? This is known as voir dire test. A. Examination of the accused, B. Re-examination of witnesses, C. Examination of Parda Nashin lady witnesses, D. Examination of child witnesses. Voir dire test. It is regarding examination of child witnesses, D. 89th question. In which case Supreme Court laid down guidelines against sexual harassment of women at workplace? Aruna Shanbhag, Narayani versus District Judge, R.C. Cooper versus Union of India, and D. Vishaka versus State of Rajasthan. Yes, Mir, your answers are coming. I can see, okay? It's correct, no, so I am not saying anything. It is D. Vishaka versus State of Rajasthan. Yeah, you are actually good in this. Are you from Kerala? I think you can easily clear. So, 90th question. What is meant by parole evidence? A. Collateral evidence, B. Direct evidence, C. Documentary evidence, and D. Oral evidence. What do you mean by parole evidence? Oh, you are from Kashmir? Okay, very nice. You are attempting Kerala question papers. That's a great thing. Parole evidence means oral evidence. Okay. As per English law, it is the oral evidence. 91st question. Which is a law journal published in Kerala under the authority of Government of Kerala? A. Kerala Law Times, B. Kerala High Court Cases, C. Indian Law Reports, Kerala Series, and D. Kerala Law Journal. So, this is completely, it is same, right? Yes, except some local laws. Law is same and with some state amendments. So, even when I was preparing for state Karnataka state judiciary examination, I used to attempt Kerala question papers. So, that is why I am fond of solving this, because it is easily relatable. Law is same, and in Kerala High Court website, question papers are easily available. Other during 13, 14 and all, other states wouldn't have uploaded. Now they are uploading, but Kerala used to upload very long back only, all the question papers along with answers also. Okay, so what is the answer here? It is Indian Law Reports, Kerala Series. Okay, 92nd question. The legality of narco analysis test was considered by Supreme Court in which among the following decisions? This is again a repeated question. It is, I think no need to discuss on this. It is Selvi versus State of Karnataka. 92C. The 93rd question. Which was the state law involved in Keshwananda Bharati's case? A. Kerala Land Reforms Act, B. Kerala Education Act, C. Kerala Stamp Act, and D. Kerala Abkari Act. Abkari means Excise Act, excise. So it was the land reforms which was challenged in this Keshwananda Bharati. The main Keshwananda Bharati, which case we have. The law which was challenged was the Kerala land reforms. A is the correct answer. 94th question. PW3 deposed that in a trial under section 420 of IPC, he went to the shop of accused, purchased an item and hurriedly left. After reaching home, he found that the accused had not given the full balance. What is the logical deduction the court can arrive? A. Accused is in the habit of cheating. B. Accused did not give the full balance to PW3 either by mistake or purposefully. C. Accused is not trustworthy. And D. Accused is a bad person. If we left hurriedly, what logical deduction we can have? It's either B. Either by mistake or purposefully he did not give the balance amount. 94th one. Then the 95th question. The writ jurisdiction of High Court is wider than writ jurisdiction of Supreme Court. Examine the correct answer. A. Yes, Article 226 can be invoked to establish fundamental rights and any other right. B. No, Article 32 is wider. C. Both jurisdictions are identical. And D. None of the above are true. It is A. Yes, Article 226 can be invoked to establish fundamental rights and any other right. 96th question. Subordinate courts are dealt with in which chapter of Part 6 of the Constitution of India? A. Chapter 3, B. Chapter 4, C. Chapter 6 and D. Chapter 5. Subordinate courts. This pertains to Chapter 6. Next 97th question. Okay. This is just a kind of a analogy. Lemon is to orange. Then potato is to carrot, apple, cabbage and pineapple. Potato is something which is grown underground. Similarly, even carrot and it's also a vegetable, but cabbage is there. This can't be related, but potato and carrot we can relate it to underground. That's why A, carrot. Next one, 98th question. Butter is connected to ghee, but it is not connected to A, sugar, curd, milk and cheese. It is a simple question. It is not connected to sugar. It's connected to everything, curd, cheese, milk. 99th question. Pick out the odd from the following. A. Comptroller and Auditor General. B. Chief Justice of India. C. Attorney General of India. And D. Ombudsman. All the above three are constitutional positions, whereas this one ombudsman, it is something, it is banking ombudsman, SEBI, those are not constitutional position. They may be created by statute. That's why this is the order one. And the last question for 2020 question paper, Supreme Court has no original jurisdiction in relation to which among the following? A. Dispute between two states. B. Election to the post of President of India. C. Appointment of governor. And D. Interstate water dispute. So, Supreme Court does not have original jurisdiction with respect to the appointment of the governor. Original jurisdiction we can refer to Article 131. Even interstate water dispute Supreme Court can, it has original jurisdiction. Okay. So, thus we have completed 100 questions so far of 2020 year. Tomorrow same timing we will be having from 9 to 10:30 or 10:45. We will be solving 2019 question paper with same questions, same means 100 questions for the same pattern. Okay, thank you Meera, thank you Meer Yasra for being with for being in this session and actively participating, actively answering also. Most of your, like about 90 to 95 questions, I think answers were correct by you, like whatever you said. Okay, and even Vinny had participated, even Aarti joined in between. So thank you all of you for joining. And one more thing, and everyone will be knowing about Unacademy. With respect to the Unacademy updates, I want to say Unacademy main test series are available, which is only for 2,999, and you can use my code Aparna Law for availing the discount, and this offer is valid for the first 100 subscribers. Okay, and the main test series for Punjab Judiciary 2023, this is available for 4,999. Then we have Chhattisgarh Judiciary Prelims mock test series for 500 rupees. Then different batches are there, as I had earlier mentioned. It was Safalta 4.0 comprehensive batch, which is for 12 months. Then linking batch for RJS and GJS, 6 months. Revision batch for Uttar Pradesh means examinations, 3 months we have. And this is a very important update that Unacademy is conducting free All India Judiciary Scholarship Test. So rankers will be getting a chance to avail up to 100% scholarship test. This test is on March 5th, 12 o'clock exactly. So you can scan this QR code to directly enroll into the test. You will be getting the notification when the exam begins. Then today is the last day of the offer. So anyone who wants to join, who want to purchase a subscription with a discounted price, who want to save the money, today is the last date. By 12 o'clock this offer gets over. You can use my code Aparna Law to avail all these kind of discounts. See, you can save up to about 10,000 in 6 months duration, and about 13,000 for 12 month subscriptions. So that's a very good offer. You can use my code Aparna Law to get such discounts. Okay, and daily my classes will be in Unacademy. Plus courses are also there. Right now I am taking Karnataka Judiciary batch, and also some other special classes related to multiple choice questions. It's on Thursday 10 o'clock. We'll be having a multiple choice question series on order 31 to order 40. It's a part of a series. So do join those sessions, and if you have any doubt you can ask me in the next session. So thank you all of you.